My name is Catherine Ellison and I am 43 years old. I want you to picture something for me. A room full of 30 strangers, some sitting on folding chairs, some standing against the back wall, a few perched on windowsills because there were not enough seats, a conference table at the center covered in documents. Papers I'd been carrying in a manila folder for 11 months. And at the far end of that table, my mother-in-law, Margaret Holloway, aged 67, wearing the same cream cardigan she wore to my husband's funeral, her hands folded in front of her as though she was about to lead a prayer meeting rather than receive the accounting of what she had done. I did not raise my voice that evening. I did not cry. I did not make a single accusation without a corresponding document slid across that table to support it. What I did do was read. I read aloud, word by word, the foundation deed that my husband Daniel had filed with the county clerk's office on March 14, 9 years ago, 3 months after our daughter Lily was born. 3 months before his diagnosis. A deed that named Lily Ellison as sole beneficiary of the Daniel Holloway Memorial Education Foundation. A deed that specified, in language a first-year law student could parse, that the funds in that foundation could be used for one purpose and one purpose only: the documented education expenses of Lily Ellison until her 25th birthday. $165,000 spent on furniture. On recliners, specifically, 7 of them. In a house that already had seating for 14 people. And the 30 strangers in that room? They were the foundation's registered donors. Each one had written a check in Daniel's name. Each one had a right to know. I watched Margaret's face when I said the number out loud for the first time in front of witnesses. And I understood in that moment that composure is not the absence of emotion. It is the weapon you choose when you have decided to win. Before I go any further, if you just felt that, if something in your chest tightened the way mine did on the evening I walked into that room, I want to ask you something. Drop in the comments where you are watching from and what time it is there. I find it remarkable the hours people choose to sit with stories like this. Late night, early morning, commute, lunch break, alone. Wherever you are, I see you. And if this story, my story, is something you need to hear all the way to the end, please subscribe. Not because of an algorithm, because I spent 4 years building the courage to tell this out loud, and there is something that happens to a woman when she knows she is not speaking into empty air. You are not empty air. Stay with me. I grew up in a town called Harlan's Creek, Kentucky, a place small enough that the only stoplight blinked yellow after 9 p.m., and large enough to have 2 churches that did not speak to each other. Population 1140, according to the sign at the town's edge, though everyone knew that number had not been updated since 1987. My father, Robert Ellison, was a civil engineer for the county. Not a glamorous career, but a precise one. He spent his working life measuring things: the load-bearing capacity of bridge beams, the grade of rural roads, the distance between here and the point where something would fail. He was a quiet man who expressed love through competence. He changed the oil in my mother's car every 3,000 miles without being asked. He checked the smoke detectors the first Sunday of every month. He showed up. That was the language he spoke. My mother, Patricia, was a different creature entirely. She was warm the way a fireplace is warm, beautiful to look at, generating real heat, but positioned in such a way that only certain people could get close enough to feel it. Her name was always said with a softness in Harlan's Creek. People liked Patricia Ellison. She organized the church bake sale every October. She brought casseroles to families in crisis. She was photographed smiling at every community event for 20 years. But at home, there was a calculus I learned early and could never fully solve. I have a brother, Thomas, who is 3 years older than me. And Thomas. Thomas was the answer to every question my mother had ever silently asked the universe. He had her eyes, her laugh, her ease with strangers. He walked into rooms the way she did, as though the room had been waiting for him. I used to watch people's faces shift when Thomas entered a space. Something relaxed. Something opened. I did not have that effect on rooms. I was, by my mother's assessment, too serious. She said it the way other people say, too tall. As a fact about my body she could not do anything about, and had mostly made her peace with. At 7 years old I organized my books by subject and then by author's last name, and she looked at the shelf and said, "Catherine, you're going to run everyone off." She was not being cruel. She genuinely believed it. At 9, I entered the county's junior science fair with a project on water filtration, a system I built from a plastic bottle, gravel, sand, and activated charcoal that I ordered with 3 weeks of saved-up allowance. I came in second place. The judge wrote on my scorecard, impressive design, excellent documentation, could smile more during presentation. I taped that scorecard to the inside of my closet door and stared at it for 2 years. Not because it hurt me, because I was trying to understand a world in which smiling was a criterion for scientific merit. Thomas came to the fair. He took one look at my project and said, "Cool, Kathy," and went to go talk to his friends. My mother took a photograph of Thomas and his friends. I am in the background, blurred, holding my filtration unit. I am not telling you this to make you feel sorry for me. I am telling you this because a girl who learns early that she will not be photographed unless she inserts herself into the frame develops a very specific set of skills. She learns to document, she learns to build, she learns to hold evidence. We were not poor by Harlan's Creek standards. My father's salary was steady and he was careful with it. But there was a private school 40 minutes away that Thomas attended from the 6th grade onward, his tuition covered by a combination of a modest academic scholarship and significant financial sacrifice by my parents. I attended public school. My mother explained this by saying Thomas needed the structure of a private environment. What she meant, and what I understood without being told directly, was that Thomas's potential was worth investing in, and mine was assumed to be self-sustaining. I did not argue. I made valedictorian of Harlan's Creek County High School with a 4.0 GPA and a full academic scholarship to the University of Kentucky. My mother cried at graduation, and I want to be fair here, she did cry, real tears, but her first words when the ceremony ended were, "Thomas got into the management training program at First National." He had been in that program for 3 weeks at that point. She had found a way to make the two things simultaneous in her mind, his beginning and my culmination, and had chosen to lead with his. I drove to Lexington 3 weeks later with a single duffel bag, $400 in a savings account, and a deep and clarifying certainty that whatever I was going to build, I was going to build it myself. At university, I studied structural engineering, my father's field. But I'd always understood, on a cellular level, the logic of load distribution. The idea that a structure does not fail all at once. That failure is a process of small miscalculations accumulating over time until the margin disappears. I understood this about buildings. I was still learning to understand it about families. I worked 22 hours a week at the university library, reshelving books and manning the circulation desk during the overnight shifts on Thursdays. I ate a lot of oatmeal. I bought my winter coat from a Goodwill on Limestone Street for $11. I tutored 3 undergraduate students in calculus at $15 an hour, money I tracked in a small ledger I still have somewhere in a box marked before. I graduated in 4 years with a 3.89 GPA and an offer from a mid-sized civil engineering firm in Lexington. My starting salary was $41,000, not extraordinary, but real, and mine. My mother came to my graduation also. She brought Thomas. He shook my hand after the ceremony as though we were distant acquaintances. My mother took a photograph of the two of us that day, the first photograph she had taken of me alone at an achievement since my kindergarten graduation, and even then, she had posed Thomas behind me, hands on my shoulders, his grin wide, my face almost lost beneath the paper graduation cap. Harlan's Creek does not give its daughters much to carry into the world except the memory of what it felt like to be underestimated. I have found over the years that this is not nothing. That memory is a kind of compass. It does not tell you where to go. It tells you what you refuse to go back to. I would meet Daniel Holloway 2 years into my career at a professional conference in Louisville. He would become my husband, my partner, the father of my child, and the reason I would spend the second half of my 30s learning that grief and betrayal can arrive from different directions at the same time and still land on the same woman. But that is further into the story. Let me stay here, in the library stacks at midnight, for one more moment. Let me stay here where I am 20 years old and certain of exactly one thing, that I will build something that cannot be taken. I did not know yet that cannot be taken is not a structural property, it is a hope. And hope, like everything else worth having, requires maintenance. Daniel Holloway was not what I expected when I walked into the Regional Infrastructure Development Conference in Louisville on a Thursday in April. I expected the usual, men in khaki who talked about load factors and procurement cycles and then complained about the craft beer selection at the hotel bar. Daniel was at a side table reviewing printed schematics with a red pen, and he had circled something on page 14 and written, in small, precise letters, "This assumes perfect soil density, optimistic." I stopped. I looked at the annotation. I said without thinking, "It also ignores the drainage variance in the southeast quadrant." He looked up. He said, "What drainage variance?" And we talked for 3 hours. He was an environmental engineer, 6 years older than me, with a deliberate quality to his movements that I recognized. The quality of a person who has learned to think before acting, because acting carelessly has cost them something before. He was from Bowling Green originally, the youngest of 3 sons of Margaret and Harold Holloway, and he spoke of his family with the careful warmth of someone who loves a place that is also, on occasion, disappointed him. We dated for 14 months before he proposed. I want to be clear about those 14 months, they were not perfect. Daniel was conflict-averse in a way that sometimes exhausted me. He would smooth things over when they needed to be examined. He would choose the peace of a room over the discomfort of honesty in ways that I, a woman built by contrast for uncomfortable honesty, found baffling. But he was good. He was fundamentally good in the way that some people are good, not because they have thought carefully about ethics, but because something in their essential nature is oriented toward warmth. He brought casseroles to neighbors without being asked, the same way my mother did, except that he also brought them to the neighbors my mother would have skipped. We married in May, a small ceremony at a botanical garden in Lexington. My mother wore a hat. Margaret Holloway wore a hat that was larger than my mother's hat, a choice I noticed and filed away without comment. Daniel's father, Harold, was alive then, a quiet, bear-like man who gripped my hand at the reception and said, "You'll be good for him, you're steady." It was the most anyone from the Holloway family had said to me that was purely about me, without reference to Daniel. I have thought about it many times since. We settled in Lexington. I was promoted twice in 3 years at the firm, eventually making senior project engineer on infrastructure contracts. Daniel launched a small environmental consulting practice with 2 colleagues from his university program. We were not wealthy, but we were comfortable, the particular comfort of 2 engineers who manage money like a structure, load-bearing walls first, ornamental facades last. Lily was born in December, 7 weeks early, and for 11 days she lived in the NICU with tubes in her nose and monitors on her chest, and I sat beside her isolette for 7 hours a day and read to her from an engineering textbook, because the nurses said that voices mattered, and it was the only book I had in my bag. She was 3 pounds 14 ounces, and she was the most terrifying and magnificent engineering problem I had ever faced. A system that had initiated before it was ready and had to be kept going by will and patience, and the refusal to consider alternatives. She came home. She came home. 3 months after Lily was born, Daniel was diagnosed with a glioblastoma, a grade 4 brain tumor. He told me on a Sunday morning in March. He said the words and then he stood very still as though the words had weight and he was bracing against it. I sat down on the kitchen floor, not because my legs gave out, I want to be precise about this. Because the kitchen floor was cool and solid and I needed to be in contact with something that would not move. We spent the first month absorbing the reality of it. The second month, Daniel began making plans, the particular plans of a good and methodical man who has been told he has between 12 and 36 months, and has chosen to spend them organizing things, so that the people he loves will not have to navigate chaos after he is gone. He updated our will. He put the house in both our names. He opened the Daniel Holloway Memorial Education Foundation, not as a morbid gesture, but as a practical one. Lily would need educational funding. We could not predict what my financial situation would look like after his medical costs. Several of his colleagues and professional contacts moved by his situation wanted to contribute. The foundation was the architecture for that generosity. He filed the deed in March as I mentioned. Lily was sole beneficiary. The language was explicit and non-ambiguous. I was named foundation administrator. His mother, Margaret, was named a co-trustee with advisory authority only, a role that carried no disbursement power, only the right to be notified of annual expenditures and to attend the yearly review meeting. Margaret came to visit us 4 times in the 14 months between Daniel's diagnosis and his death. Each visit was presented as being about Daniel, being a mother who wanted to be present for her son. And she was present for him. She sat with him. She made his favorite food, a chicken and dumpling soup that he said tasted exactly like childhood. She held his hand during the difficult weeks at the end. But she also began, during those visits, to do something I noticed but did not immediately name. She began asking about money, not crudely. Margaret Holloway is not a crude woman. She would say things like, "Catherine, I just want to make sure I understand the foundation structure so I can be helpful." She would ask to see the account statements, just to stay informed. She inquired during her 3rd visit about whether the foundation bylaws might be updated to reflect the family's involvement more accurately. I said the bylaws were filed with the county and required a legal process to amend. She nodded. She made the chicken and dumpling soup. Daniel died on a Tuesday in May. Lily was 14 months old. He weighed 91 pounds at the end, and he knew who we were, and he told Lily that she had his grandmother's eyes. His father Harold's mother, a woman I never met, who he said had been, in his words, terrifyingly competent and very funny. He told me he was not afraid. I do not know if that was true or if it was a gift he was giving me. I accepted it either way. Margaret was in the room. She sat on the left side of the bed. I sat on the right. We did not speak. We breathed the same air and looked at the same person, and when it was over we both sat still for a very long time, and in that stillness I made the mistake of believing that grief was a language we shared. Shh. It was not. The first disbursement request came 9 weeks after Daniel's funeral. I want you to understand the timing. 9 weeks. Lily was 23 months old. I was sleeping in 4-hour fragments and eating whatever did not require more than 3 minutes to prepare and managing the grief of a child who was too young to name what was missing, but old enough to know that something enormous had gone. I was working reduced hours at the firm on a bereavement accommodation that would expire in 3 months. I was also in the background maintaining the foundation records because Daniel had built something careful, and I was not going to let it deteriorate. The request came via certified mail. A formal letter on personal stationery. Margaret had personal stationery, cream with a navy border, requesting a disbursement of $22,000 from the Daniel Holloway Memorial Education Foundation to cover family legacy preservation expenses and household necessities befitting the foundation's purposes. I read the letter 3 times. Household necessities befitting the foundation's purposes. The foundation's purpose was, as stated in the deed, the documented education expenses of Lily Ellison. I called Margaret. She answered on the 2nd ring, which told me she had been expecting the call. I said, "Margaret, I received your letter. Can you walk me through what educational expenses you are referring to?" There was a pause, approximately 4 seconds, which is a long pause in a phone conversation, and I counted it. She said, "Catherine, I think we have different interpretations of what the foundation can support." I said the deed is not interpretive, it specifies education expenses, documented for Lily. She said, "Daniel would have wanted his family taken care of." I said, "I will need itemized documentation of any education-related expenses before I can process any disbursement. I'll send you the standard request form by email." She said, "Catherine, I don't think that's the spirit of what Daniel intended." I said, "The deed is the spirit of what Daniel intended. He filed it with the county clerk." She hung up. I sat at my kitchen table for a long time after that call. Lily was in the other room watching a program about a small dog who solved problems with the help of his neighborhood friends. I could hear the theme song. I sat with the certified letter in my hands, and I thought about Daniel telling me he was not afraid, and I wondered if he had anticipated this and had not told me because he was trying to protect me, or if he had simply trusted, the way he always did, that things would work out. The second contact came 11 days later. This time it was Thomas, not my Thomas but Margaret's eldest son, Daniel's brother, Martin Holloway. Martin called my cell phone on a Wednesday evening. He said, "Catherine, I think there's been a misunderstanding with Mom." I said, "There's no misunderstanding, Martin. I received a disbursement request that doesn't align with the foundation's stated purpose." He said, "She's been through a lot. We've all been through a lot." I said, "Yes." He said, can't you find some flexibility?" I said, the flexibility I have is the flexibility that is legally permitted under the deed Daniel filed. I'll send your mother the documentation form. Martin called 6 more times in the following 3 weeks. I answered twice. The conversations followed the same structure. He began with sympathy, transitioned to pressure, arrived at the implication that I was being unreasonable, and ended with the word family, deployed as a kind of trump card. I understand the logic. I do. When people have always used family as the argument that overrides other arguments, they are genuinely surprised when it does not work on everyone. I sent Margaret the documentation form twice. She did not return it either time. Then came the attorney letter. 8 weeks after Margaret's initial request, I received a letter from a family law attorney in Bowling Green named Gerald Fitch, informing me that his client, Margaret Ann Holloway, was preparing a legal challenge to the current foundation administration structure, on the grounds that my role as administrator represented a conflict of interest, given the breakdown in family relations following Daniel Holloway's death. The letter requested that I voluntarily transfer administrative authority to a neutral third party acceptable to all stakeholders within 30 days. I printed that letter. I printed the foundation deed. I printed my correspondence with Margaret and Martin. I put them in a manila folder. I drove to Lexington and spent $420 of my own money on a 1-hour consultation with an estate attorney named Diana Voy, who had been recommended to me by a colleague at work. Diana Voll read the documents in approximately 14 minutes, set them down and said, "Whoever drafted this deed was careful." I said, "He was an engineer." She said, "The challenge has no merit. The deed is unambiguous. Your role as administrator is secured. A conflict of interest claim requires evidence of actual misuse of funds, and there is none." She paused. "Has there been any disbursement from the foundation?" I said. "Not a single dollar. The account has grown by $4,000 in interest since it was established." She nodded. "Good, keep it that way. Document everything." I did. What I did not know, what I could not have known, because I was focused on the legal defense and on keeping Lily fed and sleeping and attended to and loved, was that something else was happening. Margaret had not waited for my approval. I discovered this 14 months after Daniel's death, during the annual foundation review that I conducted alone at my kitchen table in January, cross-referencing the foundation's bank statements with the deed requirements. The foundation account was correct. I had sole signatory authority and nothing had been moved from it without my authorization. But Daniel had also maintained a separate personal savings account distinct from our joint accounts that I had known about generally but had not immediately merged into the estate. It was an account his father Harold had left him, a modest inheritance of approximately $31,000, and I had assumed it was earmarked for something specific and had left it to process through probate with the rest of the estate assets. I requested the probate records. The account had been closed 3 months after Daniel's death. The closing balance at that time had been $28,000, reduced from $31,000 by some small withdrawals Daniel had made in his final months. Medications, a medical device rental, one small purchase from a bookstore that I eventually tracked down as a poetry collection, the last thing he bought for himself. The $28,000 balance had been transferred at closing to, I had to read the line 4 times, to a joint personal account held by Margaret Ann Holloway and Martin Holloway. That was $28,000. Then I looked at the broader estate, and I found more. Daniel had, in the weeks of clarity he had in his final months, liquidated 2 small investment accounts, a brokerage account and an old Roth IRA from his first job, and transferred those funds into what was labeled in the records as a family support fund. The combined balance of those transfers was $109,000, $28,000 from the inheritance account, $109,000 from the liquidated investments, total $137,000. I sat with that number for a very long time. And then I pulled up the county property records for Margaret's house in Bowling Green, a thing Diana Vore had told me, almost as an aside, to do periodically, just to understand the landscape. The record showed a home renovation permit filed 6 months after Daniel's death. Scope of work, interior refurnishing, new HVAC installation, sunroom addition. Contractor invoices are public record when filed with a permit. I requested them. The furniture line items included 7 recliners from a high-end catalog, $2,030 each, $16,660 in recliners alone, plus a sectional sofa, plus 2 dining sets, plus window treatments, plus a sleep system for Margaret's bedroom that cost more than my first month's rent in Lexington, $165,000. In the weeks after I assembled these documents, I experienced something I can only describe as a very specific kind of grief. Not the grief of Daniel dying, which was oceanic, which filled every room and sat on my chest while I slept. This was a surgical grief, a grief with edges. The grief of realizing that in the weeks before he died, when he was afraid and trying to provide for his family, Daniel had been guided by someone he trusted into directing money away from his daughter, and that person had used his trust as a mechanism, had used his illness as a window. I did not call Martin. I did not call Margaret. I did not call Gerald Fitch. I called Diana Voa. I told her what I had found. She was quiet for a moment and then she said, "Catherine, this is more than a foundation dispute. Some of what you are describing may constitute undue influence." She told me what I would need to demonstrate it. She told me what I should not do unilaterally. And then she told me about the foundation's registered donors, the colleagues, friends, and professional contacts who had written checks in Daniel's name. She said, "They have an interest in knowing how the foundation is being administered. The deed is a public document. A meeting of the donor community is within your authority as administrator to convene." I said, "How many donors are registered?" She said, "Based on the filing, 31. I made a quiet decision. Not because I was angry, though I was. Not because I wanted spectacle, though what came next would become one. Because a woman who has been told her whole life that she is too serious, that she documents too much, that she should smile more during the presentation, eventually reaches a point where she understands that these are not criticisms. They are instructions from people who would prefer she not be paying attention. I was paying attention. Let me step back for a moment and tell you about the years between Daniel's death and the evening in the conference room, because those years are not a gap in this story. They are the story itself. They are the part that most people skip over when they tell a woman's story, the long, unglamorous middle where she is not recovering from something dramatic or preparing for something dramatic. She is simply working, building, getting up at 5:47 a.m. because that is when Lily wakes up, and going to sleep at 11:15 p.m. because that is when the accounting is done and the emails are answered and the child is sleeping and the house is quiet enough to remember who she is. Lily was 2 years old when Daniel died and 5 when the evidentiary picture was complete. Those 3 years were the structural period, the years when I was pouring the foundation, if you will forgive the metaphor from a woman who has spent her career thinking in foundations. I returned to full-time work at the engineering firm 4 months after Daniel's death. I had arranged a daycare arrangement with a woman named Rosalie, a retired elementary school teacher from our neighborhood, who watched 3 children on a rotating basis in her home, and who became, over the following 2 years, one of the most important people in my life. Rosalie was 63 and had raised 5 children of her own, 3 of them as a single mother after her husband left when her youngest was 8 months old. She did not give advice unless asked. She made soup. She let Lily call her Ro. She told me once, when I arrived to pick up Lily on a particularly brutal Tuesday, I had lost a project bid that morning and received Martin Holloway's 4th phone call in as many days. She said, "Catherine, you are doing more than anyone can see. That is not a reason to do it faster. It is a reason to make sure you do not stop." I wrote it on a sticky note on my bathroom mirror. It is still there. At work I threw myself into what I was good at, precision. I requested the most technically demanding projects, aging bridge assessments, stormwater infrastructure analysis, school district facility reviews where safety margins had been allowed to erode over years of deferred maintenance. My supervisor, a practical woman named Elaine Forsyth who had been navigating male-dominated engineering environments for 31 years, noticed. 6 months after my return, she gave me the lead on a county bridge rehabilitation project worth $4.2 million, the largest project the firm had managed in 3 years. I had never led a project that size. I said yes before she finished the sentence. The bridge project ran for 11 months and came in 2% under budget with 0 change orders, which in public infrastructure work is the equivalent of a standing ovation. Elaine called me into her office the week the final inspection was signed and said, "Catherine, what do you want? Not what position, not what salary. What do you want?" I said, "I want to be a partner." She said, "Then let's talk about what that looks like." I became a partner at the firm 18 months later. My income nearly doubled. I bought a house, a small one, 3 bedrooms, good bones, a backyard that needed work, and Lily and I began, methodically, to improve. We planted tomatoes the first spring. They died. We planted them again the second spring. 3 of them survived. We ate them in August with salt and bread, and Lily said they tasted like the best red things in the world. And I put that in my journal because I have always believed in documentation. I also, during this period, began to build a very different kind of record. Diana Vole had told me what I needed. I compiled it over 28 months, not obsessively, not to the exclusion of my work and my daughter and my tomatoes, but consistently. I requested estate records through the proper legal channels. I ordered certified copies of the probate filings. I corresponded with the contractor who had done the Holloway renovation, a straightforward man named Carl Briggs who had no stake in the outcome and who confirmed, when asked, the scope and cost of the work and the account from which payment had been received. I consulted a financial forensic specialist, a woman named Patricia Ang who worked primarily with estate litigation cases, who reviewed my assembled documentation and provided a written analysis of the fund flows. The picture that emerged was not ambiguous. $137,000 in estate assets had been directed, in the weeks of Daniel's most profound vulnerability, from what he believed were family support arrangements into accounts controlled by his mother and brother. A further $28,000 in renovations had been drawn from those same accounts within 6 months of his death. The documentation of any educational arrangement for Lily, any arrangement at all, however informal, was entirely absent. There was no letter, no conversation, no email, no account, no plan. There was, instead, a sunroom. And 7 recliners. I want to be careful here about something. I have spent a great deal of time, in the years since, examining Daniel's role in this. He was not a fool. He was a careful man and a precise thinker. But he was also dying. He was afraid. He loved his mother in the particular and complicated way that youngest children sometimes love difficult parents, with a loyalty that overrides evidence. I believe Margaret told him that what she was arranging was for Lily's long-term benefit. I believe he heard what he needed to hear. I do not believe he understood what he was authorizing. That understanding costs me something to hold. I hold it anyway because it is true, and because truth, even uncomfortable truth, has always been the only currency I trust. What I had, what I built in those 28 months, was not a case for a courtroom, at least not yet. What I had was a case for transparency, a case for the people who had trusted Daniel's name to know what had happened to the institution built on that name. Diana Voy and I drafted the donor notification letter together. We sent it to all 31 registered donors, colleagues of Daniel's, a former professor, 3 people from our neighborhood, several of his family friends. We invited them to an informational meeting. We booked a conference room at the Lexington Public Library. We arranged folding chairs. 30 of the 31 came. The one who did not come was Margaret Holloway, whom I had, as required by the Foundation bylaws, also notified in her capacity as co-trustee. She did not respond to the notification. She did not send representation. She did not call. She arrived in person at the conference room unannounced, 45 minutes before the meeting was scheduled to begin, and sat at the far end of the conference table in her cream cardigan and waited. I arrived 30 minutes later. I set my manila folder on the table. I looked at her across the length of that table and she looked back at me, and neither of us said anything for a full minute. And then the donors began to arrive. Okay. I need to stop right here for a moment. 30 people in that room. Margaret at the far end of the table. My manila folder. The foundation deed. Before I tell you what happened next, I want to ask you something in the comments, and I want you to be honest with me. If you were in that room, as one of Daniel's donors, and you were about to find out that the foundation you contributed to had been compromised, what would you do? Option A, leave immediately and handle it privately. Option B, stay and let the administrator speak. Option C, confront Margaret directly. Tell me your letter in the comments. I am genuinely curious about you, the person watching this right now. And if you have not subscribed yet, the confrontation is coming. You will want to be here for it. I want to tell you what it feels like to walk into a room where your grief has been waiting for you. Because that is what that conference room was. Every person in those chairs had known Daniel, had shaken his hand, had eaten at his table, had believed in something he believed in. Several of them had been at his funeral. One woman, a former colleague named Ellen Marsh, had helped me carry casseroles to the house in the week after he died. She recognized me when she walked in and touched my arm and said, "Catherine," and the sound of my name in her voice, the particular sound of my name said by someone who had known Daniel alive and now knew me in his absence, almost undid me. Almost. Shh. Not here. Not yet. I had dressed carefully that morning. Not performatively. I want to be precise about the distinction. I was not trying to impress the room. I was trying to respect it. I wore a charcoal blazer I had bought for a project presentation the year before, the year the bridge came in under budget. Dark trousers. The small pearl earrings my father had given me when I made partner, his version of a standing ovation. He had found them in a jewelry store in Harlan's Creek and shipped them in a padded envelope with a card that said simply, "Proud, Dad." I wore those earrings because I needed, in that room, to know that someone who had always seen me, even imperfectly, even quietly, was present in some form. I set up the room myself, an hour before anyone arrived. I placed copies of 3 documents at each seat: the foundation deed, a 1-page summary of the fund flows prepared by Patricia Ang, and a letter from Diana Voy's office confirming the legal status of the foundation administration. I placed a small card at Margaret's seat as well. She had turned over her copy without looking at it. The room filled steadily over the course of 20 minutes. I watched the donors read, some immediately, some after they sat down. Some held the documents in their laps and looked at Margaret and then back at the documents. Ellen Marsh read every page of the deed with the focused attention of a woman who has spent her career as an environmental researcher and understands that the details in a technical document are where the truth lives. She looked up when she finished and caught my eye and gave me a single, small nod. Martin Holloway arrived 7 minutes before the meeting was scheduled to begin. He had not been invited, he was not a registered donor, but he was not excluded by the bylaws either. He was family. He stood at the back of the room against the wall in a gray suit that did not fit him as well as it once had, a detail I noticed and set aside. He looked at his mother. She did not look at him. He looked at me. I held his gaze for 3 seconds and then I looked at the clock. Margaret, I should tell you, is not a fragile woman. She is 67 and she has the posture of someone who was told in childhood that posture was a form of character. She sat with her back straight and her hands folded and she looked at the table in front of her, not at me, not at the room, but at a neutral point in the middle distance that communicated controlled patience. She had done the math. She knew that I knew something. She did not yet know how much I knew, or how precisely I could prove it. She was about to find out. The last donor arrived at 6:02 p.m. I stood up. The room settled into the particular silence of people who have read something upsetting and are waiting to understand if it means what they think it means. I have given engineering project presentations in front of city councils. I have presented failure analyses to oversight committees. I have sat across from insurance adjusters and county commissioners and explained in technical language precisely how and why a structure had not performed as intended. I know how to speak to a room that needs information and is prepared to receive it. I said, "Thank you all for coming. My name is Catherine Ellison. I was Daniel's wife, and I am the foundation administrator. I called this meeting because the foundation's registered donors have a right to a full accounting of the fund's status and management, and because there are developments you need to be aware of that I could not, in good conscience, continue to withhold." I paused. I am going to read from the foundation deed first. I want every person in this room to hear the language Daniel chose in his own words before I tell you anything else. I read the deed from the beginning. Not a summary. Not the highlights. The deed itself, in its full legal language, which Daniel and his attorney had spent 3 sessions refining because Daniel believed, and he was right, that the language had to be so clear that no reasonable person could misread it. and no unreasonable person could claim to. I read it in a steady voice at a moderate pace, the way I had been trained to read technical documents aloud at public hearings, clearly, without editorializing, without interferalizing, without emphasis designed to guide the listener's interpretation. The language guided itself. Sole beneficiary, documented education expenses, Lily Ellison. Until her 25th birthday, no other distribution permitted under any circumstances, including but not limited to family hardship, estate claims, or trustee discretion. No other distribution, including but not limited to trustee discretion. I let the silence after the reading hold for about 8 seconds. In a room of 30 people, 8 seconds of silence is a long time. I watched faces adjust. Ellen Marsh had stopped writing notes. A man in the second row, I later learned his name was Gerald Park, a former professor of Daniels, had removed his glasses and was looking at the table. Then I said, "The foundation account has not been touched. Not $1 has been dispersed since the foundation was established. Lily's account currently holds $112,000, including accumulated interest." A woman near the back said, "Oh, thank God," and I understood that some of the donors had read the fund flow summary and feared the worst about the foundation itself. "The foundation is intact," I said. "What I need to tell you about is separate from the foundation. What I need to tell you about is what happened to the rest of Daniel's estate." I opened the manila folder. I slid the first document. The probate filing. The account closure. The $28,000 transfer. This is the record of Daniel's personal savings account. The account established from the inheritance left by his father Harold. You will see on page 3 the closing transaction, dated 3 months after Daniel's death, and the receiving account. I gave the room time to find page 3. I heard the paper shuffling. I heard nothing else. I slid the second document. Patricia Ang's forensic summary. This is an analysis prepared by a certified financial forensic specialist. It traces the movement of funds from 2 investment accounts that Daniel liquidated in the final months of his life. The total moved from those accounts, $109,000. Combined with the savings account transfer, $137,000. I paused. All of it directed to accounts controlled by Margaret Holloway and Martin Holloway. There it was, the sound I had been expecting from multiple points in the room at once, not a theatrical gasp. A real one. The sound of people updating their understanding of a situation. Margaret's hands, still folded on the table, did not move, but her jaw tightened. I watched it happen from 20 feet away. Martin, at the back of the room, said, "That's not the full context." I looked at him. I said, "Martin, you are not invited to this meeting as a stakeholder. You are welcome to remain. You are not welcome to interrupt the presentation." I said it without heat. I said it the way I would say to a junior engineer that his comment would be taken at the end of the briefing. He said nothing further. I slid the third document. The contractor invoices. These are the invoices from the renovation of the Holloway family home, filed with the Bowling Green Building Permit Office. The renovation was completed 8 months after Daniel's death. The total cost of the renovation was $165,000. I let that settle. I want to direct your attention to the furniture line items on page 2. I waited. I watched 30 people read the same line. 7 recliners. The recliners, I said, cost $16,660. A man in the front row made a sound that was not quite a laugh and not quite a groan. Gerald Park, the professor without his glasses, put them back on. Then Margaret spoke. "Catherine." Her voice was controlled. I will give her that. She had the composure of a woman who has managed difficult conversations in front of audiences before. "You are presenting a selective account of a complicated family situation." "I am presenting documented financial records," I said. "If there is documentation I have missed that provides additional context, I would ask you to produce it now, in front of this room." "Daniel wanted his family taken care of," she said. "He told me that. In this very specific conversation during his final weeks." "Do you have documentation of that conversation?" I asked. Not aggressively, not triumphantly. Just, "Do you have documentation?" She blinked. "It was a private conversation between a mother and her dying son. I understand. And I want to be respectful of that." The difficulty, Margaret, is that the deed Daniel filed with the county clerk 13 months before that conversation specifies, in legal language he reviewed with an attorney, what he wanted. It specifies it clearly enough that his attorney told me when I consulted her about your initial disbursement request, that the language leaves no room for interpretation. I set the deed on the table between us. That is what Daniel wanted, the written version. The permanent version. The version that did not depend on memory or interpretation. Silence. Margaret looked at the deed. She looked at her folded hands. She looked at her folded hands. She looked finally at me. You are doing this to punish me, she said, and in her voice. I want to be accurate about this. There was genuine belief. She genuinely believed that. She had constructed a narrative in which my assembly of documented facts was an act of aggression, and in which her appropriation of her son's estate was an act of love. The cognitive architecture of it was something I had spent time trying to understand. I had come to the conclusion that some people are not capable of distinguishing between the two. I am doing this, I said, because 31 people in this room and the one who could not be here tonight wrote checks in Daniel's name. They trusted his name with their money. They deserve to know what happened. I looked at the room, not at Margaret. The foundation is safe. Lily's education is protected. The irregularities in the broader estate are a legal matter that Diana Voy's office is addressing through the appropriate channels. I am not asking anyone in this room to take action tonight. I am asking you to know. Ellen Marsh raised her hand. She said, "What happens to the foundation if there's a legal challenge?" "The foundation is a separate legal entity from the estate," I said. "Its assets are ring-fenced. Margaret's advisory role as co-trustee does not carry disbursement authority and cannot be used to challenge the foundation's structure." I looked at Margaret when I said it, not to wound her, because it was information the room needed to hear clearly attributed. Gerald Park said, "The money that went to the renovation, is there a legal mechanism to recover it?" "That is what Diana Voy's office is currently evaluating," I said. "I will share updates with the donor community as they are available." Another donor, a woman in the third row whose name I would later learn was Joanna, a colleague of Daniel's from his consulting days, said, "I want to say something." I nodded. She said, "I wrote a check to this foundation because Daniel asked me to, 3 months before he died. He sat across from me at a coffee shop and he said he wanted Lily to have options. He said, 'She's going to be extraordinary, Joe, and I want her to have the money to act like it.'" She stopped. She looked at Margaret. She said, "I'd like that money to do what he said." I pressed my teeth together for a moment behind closed lips. I let the silence do the work. Margaret stood up. She stood slowly, with the dignity of a woman who has decided that the correct response to an untenable situation is a graceful exit. She said to the room in general, "This is not the appropriate venue for a conversation of this complexity." She picked up her purse. She looked at me one last time. She said, "Daniel would not have wanted this." I said, "Daniel wanted Lily's education funded. Everything I have done has been in service of that." She left. The room watched her go. Martin followed her, without speaking, without looking at me. The room was quiet for a moment, and then Gerald Park said softly, "Well done, Catherine." And I did not know what to do with that, because I had not done this for approval. I had done this because 30 people in a room deserved to know what had happened to the name they had trusted, and because a 14-month-old girl had been left without her father and the money her father had spent the last clarity of his life arranging for her. I closed the manila folder. I said, "Thank you for coming. I'll be in touch through Diana Voy's office with any legal developments. If you have questions in the interim, please reach out to me directly." People stood. People spoke to each other in low voices. Ellen Marsh stayed until almost everyone else had gone, and then she hugged me briefly and said, "He was so proud of you." I said, "Did he tell you that?" She said, "Every time I saw him." I accepted that. I held it carefully, the way you hold something that might break. I collected my documents. I stacked them back into the manila folder. I turned off the lights in the conference room and walked out into the parking lot and sat in my car for 11 minutes before I could drive, not crying. Just breathing. Just remembering that I had come here to do a thing, and I had done it, and that sometimes the hardest part of doing the right thing is that it does not feel triumphant. It feels like grief with paperwork. In the 2 weeks following the donor meeting, I did 4 things. First, I met with Diana Voy and her estate litigation colleague, a man named James Okafor, and formally authorized the civil recovery process. The case was not airtight, undue influence cases rarely are, but it was strong. Patricia Ang's forensic analysis was solid. The contractor invoices were solid. The probate records were public. James told me it would take between 8 months and 18 months to resolve, through a combination of formal demand, mediation, and potentially court proceedings if Margaret and Martin declined to settle. I told him to proceed. I went home and I made oatmeal, not because I was being symbolic but because it was 10:30 at night and it was what I had. Second, I sent a letter to Margaret. Formal, written, brief. It established 3 things clearly: that I would have no further direct personal communication with her outside of legal proceedings, that I would facilitate Lily's relationship with the Holloway family through a structured visitation arrangement reviewed by a family mediator, and that I wished her no harm. That last point matters to me. It is not a performance. I genuinely do not wish Margaret Holloway harm. I wish her distance. Those are different things. And I needed her, and the legal record, to understand the difference. Third, I sat down with Lily. She was 5 years old at this point, which is old enough to sense that something significant is happening and not old enough to understand the particulars. I told her that some things had happened with Papa's money that we were working to fix, and that we were going to make sure his wishes were honored. She said, "What wishes?" I said. "He wanted you to have money for school." "We're making sure you get it." She considered this. She said, "What if I don't want to go to school?" I said, "Then we'll talk about it when you're old enough." She said, "Okay," and returned to her drawing. She was drawing a bridge. I had not told her to. She had been watching me work one evening when I was reviewing bridge inspection photographs for a project, and she had decided, entirely on her own, that bridges were interesting. She was 5 years old and she was drawing bridges, and I sat across from her at the kitchen table, and I thought, okay, he was right. She is going to be extraordinary. Fourth, I established a structured boundary with my own family. My mother called me the week after the donor meeting. Word travels, even between Harlan's Creek and Lexington, and she said in the sympathetic tone she reserved for situations that confirmed her existing assessments, "Catherine, I always worried you were too rigid. That this kind of thing was going to." I said, "Mom, I love you, I will call you Sunday," and I hung up. Not with anger, with architecture. The same way you remove a wall that is not bearing load, not violently, just, "This structure works better without this here." Thomas, my actual brother, texted me 3 days later. He wrote, "Heard what you did. Good for you. I'm sorry I'd been useless. Can I call?" I looked at that text for a long time, and then I wrote back, "Sunday works." Because Thomas being useless is not the same as Thomas being irredeemable. And because my father, who checked the smoke detectors the first Sunday of every month and changed the oil every 3,000 miles, had once told me that the difference between a repairable structure and a condemned one is not the severity of the damage. It is the quality of what was built underneath. Thomas and I talked for an hour and 40 minutes that Sunday. He apologized 3 times, once at the beginning, once in the middle, and once at the end. By the 3rd time, I believed him. We are not close the way we might have been in a different version of childhood. But we are in contact, which is more than we were. Martin Holloway sent a single text to my phone 2 weeks after the meeting. It said, "What you did was cruel." I did not respond. There was nothing to respond to. A man calling the documentation of financial misconduct cruel is a man who has confused accountability with aggression. I did not have the energy or the inclination to help him sort that out. The recovery process moved forward. 14 months after the donor meeting, the civil matter resolved through mediation. Margaret and Martin agreed to a settlement of $104,000, returned to the estate, from which, after fees, approximately $91,000 was directed into a new educational trust account for Lily that was legally distinct from the foundation and administered under court oversight. The foundation itself continued, growing with additional interest. By the time Lily turned 7, her combined educational funds exceeded $200,000. Margaret did not return any communication from Diana Vore's office until the fourth formal letter. She did not acknowledge the settlement at any point as related to misconduct. The settlement agreement used language like family disagreement regarding estate administration, which is the kind of language that allows everyone to sign and no one to admit anything. James Okafor told me this was standard. I said I understood. I signed. It was not the language I would have chosen, but the number was the number, and Lily's account reflected it. Gerald Fitch, the Bowling Green attorney who had sent me the initial threat letter, quietly withdrew from further representation of Margaret within 2 months of the donor meeting. I do not know what passed between them. I did not ask. Martin Holloway moved to Nashville the following spring. I know this only because a mutual acquaintance mentioned it in passing. I have not spoken to him since the conference room. My life settled into the shape it has now, which is not dramatic and is exactly as good as it looks. I was promoted to managing partner at the firm 18 months ago. Lily is in 2nd grade and is, by her teacher's assessment, exceptionally analytical and occasionally too literal in her reading of instructions. I have framed that note and put it on my refrigerator. I recognize the child in that description. I know exactly what she will build with it. I placed 2 objects on the windowsill of my home office last autumn. The first, a framed copy of the foundation deed. Not to remind me of the pain, but to remind me of Daniel's precision, his foresight, the evidence of his love in the form of specific legal language. The second, a photograph of Lily at age 6, standing in front of the 3 surviving tomato plants in our backyard, holding one in her open palm and looking at it with the focused attention of a child who is trying to understand exactly what she is holding. That is what I am trying to give her, the habit of holding things carefully and looking at them clearly. Everything else, the recliners, the cream cardigan, the 8 seconds of silence in a conference room on a Thursday evening, everything else is context. Lily is the text. If you are still here, and I believe you are because you have always been someone who stays through the difficult parts, I want to speak directly to you for a moment. Not about my story, about yours. There is a particular cruelty reserved for women who pay attention, who document, who speak clearly in rooms where people would prefer them to be confused. We are called rigid, too serious, difficult, cold. We are told that we are missing the spirit of things, the spirit being, in most cases, the unspoken agreement that we will accept things as they are presented rather than as they demonstrably are. I was told to smile more during my science fair presentation. I was told that I would run everyone off. I was told that Daniel would not have wanted what I did in that conference room. Daniel wanted his daughter's education funded. The deed said so. I made it happen. That is the whole of it. But I want to say this to you specifically if you are a woman who has been told that your precision is a flaw, your documentation is a pathology, your composure is coldness, your boundaries are cruelty, they are wrong. Every single one of them is wrong. Precision is how you protect what matters. Documentation is how you make truth durable. Composure is what you carry into the rooms where you are outnumbered. Boundaries are what you build so that the people who depend on you, your children, your future self, the version of you who will be 43 and sitting in a conference room with a manila folder, can function. You are not too much. You are exactly enough, pointed in the right direction. Build the thing. Document it. File it with the county clerk. Show up to the meeting. And if no one in the room will believe the numbers, read them aloud until the numbers speak for themselves. That is what I did. That is what Daniel taught me to do, in the 3 months between Lily's birth and his diagnosis, when he sat at our kitchen table with an attorney and an engineering mind and built something careful enough to survive the worst. I honored it, Lily will honor it, and if you have a story like this, if you are holding a manila folder and you do not know if the room will be ready, subscribe, come back, I will be here. This channel is for women who build things that last. Good night.